Hey, I'm Tamara Kendacker, and you're listening to The Decibel from the Globe and Mail. In a landmark decision last week, the Nova Scotia Court of Appeal ruled that, like they do with Indigenous offenders, trial judges need to take into account the history of racism and marginalization that Black offenders have faced in their life during sentencing, and to do their utmost not to put them behind bars. Justice Anne Derrick wrote in the ruling, "The moral culpability of an African Nova Scotian offender has to be assessed in the context of historic factors and systemic racism." What this means is that from now on, a sentencing judge has to look into the extent to which systemic racism and marginalization, both immediate and historic, have shaped the offense and the person on trial. If they don't, this could amount to an error of law, and their sentence could be overturned on appeal. Experts are applauding the decision as a recognition that justice isn't blind, and they say the change could influence other provinces. The Ontario Court of Appeal heard a similar case in February. A 26-year-old man named Kevin Morris was sentenced to 15 months for carrying a loaded firearm. The judge took into account the anti-Black racism Morris faced growing up in Toronto and his personal background when deciding his sentence, which was lower than the 4 years the prosecution had asked for. A decision in that case is expected in the coming months.
This is not a race-based discount. Rather, it's a fit sentence when looking at all the circumstances, including historical and systematic factors.
Tanya Walker is a lawyer and managing partner at Walker Law and a bencher for the Law Society of Ontario. Tanya's going to tell us about the case at the center of the Nova Scotia ruling, about the link between crime and systemic racism, and what this decision could mean for the way that Black offenders are sentenced in the rest of the country. You're listening to The Decibel. Tanya, hi, it's great to talk to you.
Nice to meet you.
So Tanya, can you tell me about the case of Rakim Anderson, which is at the heart of this? Who is he and what was he charged with?
So Mr. Anderson is a Black man originally from Nova Scotia who was charged with carrying a loaded firearm when he was at a checkpoint stop.
Right, and this was back in 2018, and then he was on trial, and what happened during his trial?
During his trial, the trial judge relied on a report called The Impact of Race and Cultural Assessments. And that report provided information about Mr. Anderson's background and also the circumstances surrounding Black Nova Scotians. And so that judge took that into consideration when deciding what the proper sentence would be.
And what is the impact of race and cultural assessment? Tell me about what that is and how it's used across the country.
Well, it's essentially a report that is written by professionals, including social workers or those with relevant degrees. And this may include someone with a master's degree in race-related studies. And so what this report does is provide information about the individual that is charged with the crime, as well as information about where that person is from. For example, if they are from Nova Scotia, and some of the historical challenges those in that person's racialized community may have had during time.
And so in the case of Rakim Anderson, what did the impact of race and cultural assessment find?
Well, it found a few things. First is that there's racial instability in his neighborhood. There are higher rates of crime in his neighborhood. The reason why he was carrying a firearm was to protect himself. It wasn't because he wanted to hurt somebody. That he has had a lack of educational and employment opportunities where the educational system seemed to have failed him. There's a lack of Black-focused curriculum, and he had no role models. Also, there was, and I think which is fundamental, his trauma and loss, where he lost his best friend to gun violence, and that led to his fear and his perceived need to carry a weapon for safety.
And so how did the impact of race and culture assessment impact his case and the way that he was sentenced by this judge?
Well, this report allowed the judge to see the potential benefits of a conditional sentence, as it could allow for a higher likelihood of rehabilitation with available programming. My takeaway from that is if he is ordered to be on probation or to stay at home, and he is allowed to leave his home to get counseling, or there's some kind of programs available in his neighborhood, those programs actually offer a component, or they're geared towards people who are of African descent in that neighborhood, as opposed to in prison where there's no such thing that exists.
Yeah, I think part of a sentence included the stipulation that he would go to Afrocentric therapy to address trauma, that he would go to attend literacy and education program with an Afrocentric focus and perform community service, right? And so last week, there was a decision handed down from the Nova Scotia Court of Appeal. Tell me what that decision was and what the significance of it was.
So the Crown originally appealed the conditional sentence on the grounds that the judge underemphasized denunciation and deterrence and imposed a sentence that wasn't fit. But the Crown's position evolved substantially since then and was just seeking guidance on how to use the impact of race and cultural assessments report and the role that they play in sentencing. So the Court of Appeal in Nova Scotia agreed with the trial judge, and said that it is perfectly appropriate to take into account one's background and circumstances when sentencing, and that the failure to do so could actually lead to an error and a successful appeal.
So this ruling essentially makes their use mandatory in the case of Black people who are accused of crimes in Nova Scotia, right?
So the Court of Appeal 5-0 provided the takeaway that these should be used when sentencing, and to not consider it or pay attention to it may amount to an error in law and could be appealed.
Right. The significance of this ruling, I've read people say, is that it's a recognition that justice is not blind.
I agree with that. It's important to take into account someone's background and their personal life circumstances, because it's not a one glove fits all type of scenario. And I would think that the situation would be different if you are from a suburban neighborhood where there's a low level of crime and you're carrying a firearm, as opposed to your friend being killed because of a firearm, leading to your fear carrying one, and you're from a neighborhood with a higher level of crime. It should be taken into account. I do agree with that.
Yeah. So what does this ruling mean in a practical sense for racialized people who are on trial for committing a crime?
What this ruling means is that court is going to or should take into account a person's personal circumstances and background when imposing a penalty. It shows a movement to the Gladot reports, which address the circumstances of someone who's from the Indigenous community. It's actually in the criminal code, must be taken into account when sentencing. It's section 718.2 of the criminal code, to be exact. And so I see a link between these reports and the Gladot reports, because they seem to me to be quite similar. They're just reports for different communities. And it shows that there's a movement towards that for racialized communities. It sends that message to me, and I wouldn't be surprised if at some point in time it is made mandatory to consider these reports, as opposed to it's being now said, well, you should, or instead of you must.
Right. And this ruling was in Nova Scotia. And like you said, it's not binding for the rest of the country. But how could it have an impact, do you think, on the way that racialized people are sentenced across the country? Is it that judges could cite this decision in their own decisions?
Yes, they can cite this decision as persuasive authority. What I mean by that is some decisions are binding, like the Supreme Court of Canada, and there's some decisions that are made in different provinces that can be used to persuade one. And so this can be used, for example, in Ontario, to persuade the court to consider use of these reports when deciding to sentence someone or impose a penalty.
So these reports, they have been used in other places. And I wonder if you can tell me about some other cases where we've seen the impact of race and culture assessment being used.
Sure. There's a case of the Crown versus Jackson, and that was decided in 2018. And in that situation in Ontario, Mr. Jackson was originally from Nova Scotia, of African descent, and he was caught with a firearm with one bullet in the chamber while already having a gun prohibition placed on him. And the trial judge gave him a 2-year sentence for what may have been a 7-year sentence. And the trial judge did use the cultural report to inform his decision. And some things that he took into account with that report is that Mr. Jackson's mother had developed a serious mental health problem while he was in his early teens, that his father was not really present in his life. His father was in the military and often away from home. That Mr. Jackson also experienced discrimination on both ends, being a lighter skinned Black male, where he did not feel like he fit in with the Black community because he was told he was not Black enough. But then with the white community, he was too Black. And so
Mm-hmm.
he didn't feel like he belonged anywhere. So if you don't receive the education that you should have, if you don't have role models, if you don't have leadership, you're not as likely to be a productive member of society. You may believe that your only option is to be involved in crime. If that's all you see or what you're exposed to, it's understandable.
There are people who will have an issue with the idea that racialized people and indigenous people would get more lenient sentences because of the color of their skin and historical trauma that happened generations ago. And they'll say that it's unfair. And I wonder what you would say to those people.
Well, the court case that I mentioned to you from Ontario, what I would say in response to that is similar to what the judge said in that case. And the judge said there that this is not a race based discount. Rather, it's a fit sentence when looking at all the circumstances and take that into account, including historical and systematic factors. It's just a sentence that recognizes that each sentence is individually based on well recognized principles of law, and that there is a problem of disproportionate incarceration of African Canadians. And to break it down a little bit further, I just believe that in order to have proper justice, it needs to be proportional, like the sentence or conclusion needs to be proportional and specific to the crime and person. And these reports allow for that. Historically, racialized groups have been uniquely and disproportionately oppressed and marginalized through racism and systematic oppression. And and I should say our, because I am a Black woman, culture and history created unique environments which should be taken into account when trying to make a proportionate and just sentence that can help to rehabilitate. So I believe that it's not just giving someone special treatment, these reports. What I believe is acknowledging what actually exists, which are certain circumstances may have led to that person committing that crime. And that shouldn't be ignored. And if we want that particular person to be a member of society, to contribute to society, we can't ignore that. And we should help that person rehabilitate, because if that person rehabilitates in their community, then they speak to other people in their community as well, we would hope. And that could also help rehabilitate other people even before anything wrong is done.
Right. There's also the criticism that these impact assessments tend to lead to more lenient sentences that may not make people think twice about committing a crime, and they wouldn't do the job of deterring others. And I wonder what your response would be to that criticism.
I don't believe that it takes away from the deterrent part of the sentence. With rehabilitation, to me, there is a component of deterrence because once somebody is rehabilitated, they don't find the need or want to commit a crime. So I don't agree that these sentences will not lead to a deterrence. I do believe that taking into account these reports, it will lead to a greater proportion of people being rehabilitated, and that will help our society more than just deterrence. And I should note that the Court of Appeal in Nova Scotia did say there aren't any studies that show incarceration leads to a higher level of deterrence.
So, Tanya, you're a Black lawyer, and I wonder what this ruling that came down last week means to you on a personal level.
Well, being born in Toronto, I've had to overcome many hurdles due to race and gender in Toronto and then in Ajax, where I spent my formative years. And I also had to deal with issues of race and gender in my 15-year legal career. And so, having dealt with discrimination, I appreciate that decisions may be made by one which takes into account your experiences. So, I do agree that your experiences should also be taken into account when deciding a penalty, because different penalties may achieve the same result, which is rehabilitation. So, what that decision says to me is that certain circumstances that one may have, experiences that they may have, should be taken into account to ensure that that person is properly rehabilitated and can be a productive member of society.
Okay, Tanya, thank you so much for doing this.
Thank you for having me. It was a pleasure.
That's it for today. I'm Tamara Kandaker. Our producers are Madeline White and Kasia Mihailovich. Rebecca Weston is our intern. David Crosby edits the show. Angela Pacenza is our executive editor. Thank you so much to Tanya Walker. If you want to learn more about this, you can read the story about the ruling by Sean Fine at globeandmail.com. If you want to email us, you can reach us at thedecibel@globeandmail.com. If you want to reach me, I'm on Twitter at Anima_TK. We always want to hear from you. Thank you so much for listening. I'm off on vacation for a few days, so we'll have some guest hosts for the next few episodes. Watch the feed tomorrow as usual, and I will talk to you next week.